An expunction is a way for the court system to order all government entities to destroy any records of an arrest or charges that somebody has faced. It deletes the records from any digital databases as well as physically destroys all records out there. In Texas, the process is involved but relatively simple. You hire an attorney or you work with an attorney to file a petition to the court. The court then reviews that petition and speaks with all of those involved, usually somebody from the prosecutor's office that originally handled the case, as well as DPS. Then you are set for a hearing about 30 days out from when the petition is filed. The judge holds that hearing to see if you are eligible legally or if anybody objects to the expunction, and then makes a ruling and either grants or denies the expunction. Anybody who has a criminal charge or arrest can qualify for an expunction depending on how the case is resolved. If the charge is dismissed or otherwise doesn't result in a final conviction, it's possible that you can be eligible for that charge to be expunged from your record. There are details that can differ from case to case, so it's best that you consult with an attorney to find out if your specific case is eligible for an expunction. When a case is eligible for an expunction depends on what the original charge was. Oftentimes, you have to wait until the statute of limitations has passed on the charge before you can apply for an expunction. For misdemeanors, the statute of limitation is 2 years. For felonies, the statute of limitations can differ between 3 years, 5 years, or 10 years, depending on the charge. There are different circumstances where somebody might be eligible for an expunction earlier than the statute of limitations. If somebody's completed a veteran treatments court, for example, or a pretrial intervention program, those are different factors that can allow for an early expunction, as well as other things that you can work out by speaking with a lawyer to see if there's an early qualification. The process for the expunction does take a couple of months. There is a waiting period from when the petition is originally filed that the court is mandated to wait 30 days before having a hearing on whether or not the expunction will be granted. All agencies that receive the order of expunction have 180 days before they are required to delete their records and expunge all of the records that they have related to the charge or arrest. They can do it sooner. Oftentimes in today's digital world, it tends to happen sooner, but they are granted by the court 180 days before everything must be finalized and the case is officially expunged. There is no official notification from any of the agencies that are expunging or destroying the records. It's up to the individual who asked for the expunctions to follow up. In the case where you've hired an attorney, your attorney should follow up with all of those agencies to be sure that the records were destroyed in a proper manner. If you want to check on previous expunctions, you can run a background check on yourself through the Department of Public Safety. The Texas DPS allows individuals to run background checks on themselves for a very nominal fee to determine whether or not the expunction was processed successfully. There's a big difference between expunctions and non-disclosures. Expunctions completely destroy any record that any government agency has of the charge or arrest. The records will not be accessible by anybody going forward, whether they are law enforcement, courts, or private individuals. Non-disclosures are a different manner of sealing the record. When we think of somebody's records being sealed, it tends to be an order of non-disclosure. Order of non-disclosure hides the records from the general public, from a private employer or private housing, apartment complexes, that sort of thing. They are not able to access those records. As far as they are concerned, there would be no records if an order of non-disclosure is in place. However, there are certain individuals that can still access records under an order of non-disclosure. Anybody that's from law enforcement, the FBI, or certain licensing databases, such as a Texas state bar or teachers or other governmental licensing agencies. There's a full list in the Texas Code, but ultimately it comes down to law enforcement agencies, government agencies, and licensing boards. If you want a juvenile record to be sealed in Texas, you almost always have to ask for that process to be started. Most juvenile records, depending on the circumstances, would be eligible after a certain point in time, but it's not often an automatic process. It's something that has to be initiated after that charge is eligible. To start that process, you can reach out to an attorney to guide you on how to begin that process. Applying for an expunction is a very complicated process. There's often a lot of nuances involved, and you have to know how to work around the law to properly ask for certain things. If someone is eligible but it's not requested or petitioned for in the proper manner, it may not be granted. This is where an attorney comes in to be great assistance. A lawyer can help you navigate the process. They can be sure that the petition is filed accurately and correctly so that you have the best chance of being granted an expunction when you're eligible.